And I do want to initially confirm, I know I could hear him until I muted him. I can see him. Can we please get confirmation from the other courtroom that the audio and visual is working? All right, and we do have confirmation of that as well. Prior to the court ordering Mr. Brooks removed from this courtroom to the neighboring courtroom, there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom. I have cited repeatedly from Illinois versus Allen, which it is 2:39 now as I go through this decision making and put my findings on the record, but his
behavior started very early on. I gave him ample opportunity to abide by the rules of decorum. I gave him ample warning before he was removed. This court, frankly, has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings. With that, I will turn back to Attorney Opper. I am going to unmute Mr. Brooks, but also advise him that if he interrupts Attorney Opper or others as they are providing testimony here today, I understand he can object. However, my expectation for that objection process would be that he say, I object. He provide a basis. I oftentimes give parties, give me one word. Is it hearsay? Is it, calls for speculation? Is it irrelevant? Whatever it may be, a very either 1-2 word objection or a very short summary statement of the basis for his objection. After he does that, I will rule on the objection, and I expect him to honor the ruling that I have made. If he can't do any of that, he will remain muted, and the process will then be we've given him a sign. He's holding it up right now, demonstrating for us he has the objection sign. He will be required to write down his objections on a piece of paper that will be provided to the bailiff. The bailiff will provide it to me, and then I can rule on those, even if it's striking testimony later on. I do expect his objections to be based in law. He, I note, was provided with the copy of the selected statutes, including the rules of evidence.
All right, go ahead, Attorney Opper. For the record, the mute has been undone.
Thank you. So, Ms. Wollenhaupt, I was asking you about the digital discovery materials. You testified that you're aware there is a thumb drive available for Mr. Brooks' use that is maintained in his pod, and all he has to do is ask for it, correct?
Correct, ma'am.
And that in order for him to view the contents of the thumb drive, he'd have to use the computer in the conference room, correct?
Correct, ma'am.
And that is available to Mr. Brooks upon his request, correct?
Correct, ma'am.
And nothing
Hold
about...
on a second. Mr. Brooks, the basis for your objection at this time?
That it's irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room or a tablet.
Your objection is noted. It's overruled. Her answers may stand. Next, you may continue, Attorney Opper, with your next question.
The nothing about this protocol then would limit his access to any of his discovery materials, correct, ma'am?
Objection.
Overruled. She may answer. Correct, ma'am.
And he would have access to the telephone if he wants it.
Objection.
Overruled. She may answer.
Yes, ma'am.
And there would be nothing that would restrict his ability to come to court each day?
Objection.
Overruled.
Correct, ma'am.
And when he comes to court each day, he has the ability to bring whatever discovery materials with him that he wants. Is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact, there's a card available for him to do that if he so requests.
Objection.
Overruled.
That is correct, ma'am. Correctional officers would transport it, but yes, there's a card available.
Sure. Mr. Brooks had told this court earlier that he started feeling not well, I believe were his words, over the weekend. And is there any notice to any correctional officer or jail supervisor that you're aware of that Mr. Brooks reported that to them?
Objection.
Overruled.
I have not reviewed the jail medical record. This came to my attention shortly before the lunch hour.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection? Or just a comment under your breath? Your objection's noted. It's overruled.
Of course.
if he were to complain of illness to a correctional officer or a lieutenant, would they document that in any way?
They would give him a medical request form to fill out, which would go to the medical department where he could have contact to medical staff, or it could be documented in the jail management system.
To your knowledge, was that done by Mr. Brooks last weekend, the weekend of September 30th and October 1st?
Not to my knowledge.
Okay. And are you aware of the fact that last weekend, on or about Saturday, he requested a shower and a shave?
Yes,
Was that provided to him?
yes.
If he were on a protocol, would he still get those things? Or does it depend?
It would depend what type of a protocol.
Okay, thank you.
Those were all my questions. Thank you, Ms. Wollenhop.
All right, Mr. Brooks, do you have any follow-up questions for Ms. Wollenhaupt?
I do. You stated that it would depend on what type of protocol I was on, would dictate if I'm able to shower, correct?
That was not completely what I stated.
Well, that's what you just stated on the record.
Well, different management protocols, it would be in accordance with jail operations, and my preference, Judge, would not to be to speak to all of the jail operations.
Right, I'm not going to require her to speak to all the jail operations. If you wanted to ask her, for example, whether your current protocol would prohibit that, I think that would be a fair question.
So that would be the question then. Well, no, let me ask this. What specific protocols would prohibit being able to shower?
Objection, irrelevant.
I'm not going to, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols given the operations of the jail, but you may ask her if there's something specific as to you.
Well, because of my situation being a little bit unique, would any protocol that I am on currently prohibit me from being able to shower and or shave?
Do you speak moving forward?
As of right now.
You would be allowed to shower on the protocol you're currently on.
Would I be able to shave?
You would be able to shave.
Would that be with the clippers or a razor?
Objection, relevance.
Overruled, she may answer.
Mr. Brooks, we would monitor behavior and other factors in that and make a determination. There's procedures operationally in the jail that you can request those items. And
So
you
that would be independent of the calls.
correct, ma'am.
So, to your knowledge, are you aware that we are only permitted, and I'm saying myself as well, being housed in the jail, that we are only permitted razors once a week and clippers only once a month?
Judge, I would prefer not to answer questions in regards to jail operations.
Right, I'll honor the request of the jail administrator. It goes beyond the scope of this hearing. She need not answer general questions about the general procedures and protocols within the Waukesha County Jail. We're a little far field. I gave you a little bit of leeway, but we had started this off about protocols and your current situation. So from my perspective, the questions regarding the discovery materials and all of that were relevant because you claimed you weren't being allowed out to a conference room. That to me implicated your ability to prepare for your defense and this trial. So that's why I allowed those questions. Whether you shower or shave would, in my humble opinion, not be relevant to the issue of whether you can assist in your own defense.
Well, respectfully, Your Honor, that was brought up by the prosecutor. It was brought up about the whole issue of being able, me requesting to be able to shower and shave, so that's why I brought it up in my questions.
I understand, and I'm under my authority, under 906.11, I'm going to advise both parties that anything regarding those types of things are not relevant, and I won't allow questions from either side regarding that any further, at least today on this particular issue.
Thank you, Your Honor. I would want to make one correction for the record. I never claimed not to be able to have access to certain things. I merely claimed that I am on a protocol which limits me even more than I'm already limited. I made no reference to anything in specific, just the fact that I'm on a protocol which restricts me to my cell until the test can come back.
I appreciate that clarification, sir. Thank you. Do you have any other questions for Ms. Wollenhup?
Yeah, a couple more.
Okay, go ahead.
Would you care to share with the court on record the types of protocols that I am currently on outside of the protocol?
Objection, irrelevant. Goes to jail operations.
Sustained. Next question.
Does my specific protocol change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm gonna have her not answer that, as it goes to.
Well, that directly goes to that, because as we know, I'm only on a protocol where I'm only allowed out of my cell a few hours a day as it is. Now being restricted to my cell because of the protocol, the question I'm asking is, does that restrict even the time that I can be able to be out to utilize the things that I need? Because essentially, I'm only limited. I'm already limited.
Can I ask?
There's times.
I want to make sure I follow you, Mr. Brooks, so I'm sorry for the interruption. If I hear what you're saying correctly, you may have a belief that your access to certain things that would impact your ability to prepare for this case is impacted by the protocols. Is that a fair assessment of what you're trying to convey?
I would say that would be accurate in a sense.
And so if we ask the jail administrator that specifically, is there anything about access to material that would interfere with your ability? Room, is that a question you would want answered?
That would be fair, Your Honor.
All right, do you understand what he's trying to
So what
ask?
I'm understanding is, obviously, Mr. Brooks is allowed to keep legal material in his cell. He will remain in his current housing location. Access to the conference room, it will not change that, which is outside of his housing unit. And access to the phone could be granted upon request in the day room area.
All right.
So I do not believe the protocol limits his access to legal material.
Thank you. Do you have any other questions?
Yes, I do. As far as she just referenced the telephone. To the best of your knowledge, are you aware that there is a certain times that the phone will be available you have other inmates that,
Let's
have
not
time
talk about
out
other
there.
inmates, but again, I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking,
Okay, let me ask it another way.
okay, go ahead.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have regularly, would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask?
I guess I'm unclear as to the manner you speak of. What are you referring to?
I think I was very clear with it.
Are you trying to
You
ask
are
her?
aware, are you aware, which I know you are, that the protocol that I'm on outside of the protocol prohibits me from being able to utilize the phone at certain times of the day? Would the COVID protocol prohibit that any further?
Mr. Brooks, are you trying to ask whether the protocol impacts your phone privileges?
That's what I just said. No, not in a sense, because I think it's more accurate with the way that I asked it.
But your question
Yeah.
assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what, if any, impact the protocol has on your ability to prepare for this case. So I'm going to limit your questioning in that way.
Well, can we at least make a clarification on the record that the reason why we're having this didn't have anything to do with limiting my preparation?
So
that wasn't the real issue.
I think it's related to
I
the.
just wanted that clarification.
I understand.
For the record, that's all.
I understand what you're saying. I respectfully disagree. That's why I've allowed some of the questioning. I believe it's relevant to the motion that's before me for this court to know how the protocol specifically impacts you and your ability to prepare for this case. I understand you might not be claiming the latter to be an issue, but nonetheless, I think it's appropriate for the court to consider those things. I heard the jail administrator indicate that the phone privileges would still be available upon request, and I guess to the extent that that's different, if at all, from the standard protocols that you're under, I would accept that as an offer of proof from you.
Well, I didn't agree to that, but the reason why I brought it up was because I've been on the outside of the protocol. The protocol that I've been on for a very, very long time. So my phone use is limited to certain hours of the day, which works out.
All right,
for
Mr.
my
Brooks, we're
family.
getting a little far field. I need to make a determination on your request, so I'll ask you one last.
You haven't let me finish what I was getting to.
Mr. Brooks, I will ask you one last time. Do you have any other questions for the jail administrator? Because right now you're talking more about things you would provide. So if you have a question that's relevant, please ask it.
I didn't say anything I would provide. Where did I say that?
When you provide information through just a statement about things, that's not evidence, right? The witness on the stand is providing us testimony. Testimony is evidence. Not that I wouldn't accept certain statements from you, but also understanding the state has the ability to challenge those by asking questions of the jail administrator or other individuals so that I can make a determination today on your motion. With that, Mr. Brooks, do you have any other questions for the jail administrator?
Well, everything you just said still speaks to not understanding that I have, Your Honor.
Mr. Brooks, one last time, do you have any additional questions for the jail administrator?
Your Honor, what you're doing right now is you're not being fair right now.
All right, Mr. Brooks has not answered, Mr. Brooks, I need to make a ruling right now, please stop. He's not answered my repeated question as to whether he has any additional questions for the jail administrator. Unless there's any further questioning from the state based upon the additional questions that were asked, then I'm gonna have her step down.
I just want to ask of the court if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wollenhaupt is on the stand. I just have a few questions related to that, Your Honor.